Thank you, Matt, and thanks everybody for coming today. Let me get something off my chest right off the bat, and that is the Texas legislature never should have passed this statute. It's ill-conceived. The definitions, they don't really make sense. The purpose was to kind of protect the little guy from getting litigation bully suing you and beating you down with legal fees and that sort of thing. But the way it was written applies much more broadly than that. And if it was intended to reduce litigation, it has totally failed that mission. Just look at the number of opinions in the Court of Appeals on the TCPA. So it has actually increased litigation, okay? And here's and I'm jumping ahead a little bit. Haley's gonna get into the definitions. But the sort of fundamental problem with the statute is that the purpose is to protect constitutional rights like freedom of speech and freedom of association. That's the stated purpose. But the definitions that decide whether it applies, they define those rights much more broadly. They are not limited to constitutionally protected rights. So that's the root of the problem, is really that tension in the statute. And really, I think it's going to take the legislature doing something to fix this. Okay, that concludes the opinion portion of the presentation today, because really what you want to know is, what does this mean for me and my practice? How can I use the TCPA in my practice? What happens if I'm hit with a TCPA motion? What do I do? Does it really apply? We want to cover those practical things. And please, if you have experiences to share about the TCPA, jump in at any time. We'd love to hear that. And if you have questions, please jump in at any time as well. So, with that, I'm going to turn it over to Haley to address the first of our 5 big issues, and that is, okay, let's say a TCPA motion has just been filed in your case. Does it really apply?
And I know that some of you are familiar with this because, as Matt said, that guy right there, Scott Smith, filed one of these against us. And it's been a really interesting journey with getting to know the TCPA. We have a love-hate relationship with it at our firm. We love it whenever we're the ones filing them. We hate it when they're filed against us. And so I'm going to just agree that I think it's going to be the legislature that has to jump in and make some changes, because right now this Texas Supreme Court has said we're going to interpret this as it's written. It says to construe it liberally, and that's what we're going to do. So does the TCPA apply? The 2 most important definitions, because there are 3 ways that it can apply. It's suits that are based on, relates to, or in response to. And it's the right of freedom of speech, the right of freedom to petition, and the right of freedom to assemble. Now, it's the assembly and the speech that we're really seeing the most of, and so those are the definitions that we kind of concentrated on. It's really what we're seeing, particularly in my area of practice, which is employment law. We're seeing it a lot in our trade secrets kind of cases. So freedom of speech is communications, and communications is defined very broadly to include almost everything, documents. It doesn't have to be just verbal speech or written speech. I mean, it's just all kinds of communications. It's made in connection with, and this is the main area, a good product or service in the marketplace. That's probably the broadest of the categories. The right of assembly is communications between individuals who join together to collectively express, promote, pursue, or defend common interests. And to be clear, the Texas courts right now are not limiting common interests to be legal, lawful interests. It can be, I mean, there's commentary right now that it can be unlawful interests. So right now, anytime you think about alleging conspiracy in your petitions, I would think twice about it, because there's been some commentary right now that anytime you have a conspiracy, you necessarily have communications between individuals who are joining together to collectively express or promote a common interest, even that if that interest is unlawful.
Yeah, I totally agree with everything you said, and let me focus this now a little bit on cases that you would typically be interested in. Let let me start with the typical sort of departing employee scenario. How many of you at some time in your practice deal with issues, let's say like a financial advisor who leaves one firm and goes to another, wants to take clients with them, there's allegations of trade secrets, there could be a non-compete, and many of you deal with that scenario. So there are some cases you'll want to be familiar with in that scenario. Probably the most important one is Elite Auto Body versus Autocraft out of the Austin Court of Appeals. That was, now it wasn't a securities case, it was just like it sounded like, it was basically like a body shop. So employees leave one body shop and go to another one and I guess take the body shop secrets, whatever those are, with them, and go to the new company. And the Austin Court of Appeals looked at this, and if you kind of read between the lines, it reads like they're saying, okay, we know this is totally crazy, but the Texas Supreme Court has told us we are to apply this statute literally. We're supposed to apply the plain meaning of these definitions. And when we apply the plain meaning of these definitions, you know, this allegation that they have communicated these trade secrets to a competitor, that falls within the definition of a communication about a matter of public concern that's in the statute. So even though we might not like this, our hands are tied. We're going to apply the statute the way the Texas Supreme Court said we should. So Elite Auto Body stands generally for the proposition that the TCPA will apply when there's an allegation of communicating trade secrets to somebody else. It kind of left open the question of what about if there's no allegation of communicating those trade secrets? What if it's just the allegation of just using them, right? Without expressly alleging that they've been communicated. That's a little more of a gray area there. Now, I've mentioned in the outline a few other cases that are also in this sort of departing employee scenario. Now, let me mention an argument, a new argument, at least to me, that just came up in my practice. So, late breaking news, I filed a TCPA motion in a departing employee case recently. It was a non-compete and trade secret case. And so the plaintiff, I was representing one of the defendants, the plaintiff filed a response, and one of the arguments raised was that both the non-compete statute and the trade secret statute, by their express language, preempt other procedures and remedies. And so the argument was those statutes preempt the TCPA. I'm only aware of one appellate opinion that addressed this issue. It was out of the Austin Court of Appeals, and it said that the issue had been waived. So I have not seen an appellate opinion that addresses this preemption issue. But watch out for that, because that, first of all, if you're on the plaintiff's side in a non-compete or trade secrets case, you probably, and you get hit with a TCPA motion, you probably want to make that preemption argument. And if you're on the defense side, you want to be ready to respond to it. I don't know yet how that's going to go. So, Haley, do you have thoughts on this preemption issue?
I generally think that with respect to the trade secret statute, the TETSA, I can see you'd have a pretty strong argument, I think, as the defendant to say preemption statute doesn't really apply because it's not granting relief in a trade secret case. The issue, I think, would be more for non-compete because there is maybe some competing language as to attorney's fees, particularly if it's a frivolous lawsuit. So that would be my kind of observation there.
Yeah, I think we kind of see it the same way as to how it's likely to come out. As many of you probably know, the non-compete statute actually does not allow typically the employer to recover attorney's fees. And that sometimes comes as a surprise to people because we tend to assume, okay, a breach of contract, if you win, you get attorney's fees, but that's not necessarily the case in the non-compete case.
So versus, the court has discretion.
Yeah, so that could be in tension with the TCPA, which, as we're going to get into later, it does authorize a prevailing defendant to recover attorney's fees. Now, let me shift gears a little bit to another scenario that many of you probably deal with, and that is more of the typical securities fraud scenario. And I have in mind more on the sort of private company level. You know, the typical, company is looking for investors, is trying to raise money, makes claims about what the company has plans to do. You know, things go wrong, and then there's a securities claim, maybe Texas Securities Act, maybe federal, and it could be a registration-based claim, or it could be a fraud claim, or both. Does the TCPA potentially apply to that kind of claim? Has anybody, I know Matt has dealt with that. Anybody else dealt with this TCPA issue in a securities case? It's pretty new, but I bet we're going to see it raised, and it was raised in a recent case that I'll tell you about. It's actually this Crestview case. There's a copy of the opinion from the Fort Worth Court of Appeals in the handout here. And I love the facts of Crestview, so bear with me a minute. I'll give you the short version. So Crestview, a lady named Armstrong has this company, and let's see, how do they describe this? Yeah, so she established a company to develop a vaginal rejuvenation product derived from human amniotic cells. So right off the bat, it's a little unusual, right? I mean, and so anyway, she has this brand new this product. She goes to Crestview looking for money, and she says, "We've got this great product. We expect sales to start soon. We have Stanford doctors researching this, and it's going to be great. Not only that, I have myself injected with this, and it worked. So this is going to be great. And in addition to that, I've got a Fort Worth plastic surgeon, Dr. Smith, on board with this. He's going to offer this procedure, and we've got him. We've worked up a website, and we even mentioned him on the website. And so Crestview says, sounds great, here's $500,000. And they invest. Okay, now, let's stop here just a moment. And I talk about this case in a little more detail in the blog post that's attached in the handout. Does anyone sense any potential problems here? I mean, you've probably dealt with situations like this. So, as you might expect, it did not work out so well. Allegedly, this Armstrong spent half the money on personal expenses, including a trip to Vegas. And I won't tell you the joke that my wife cracked about this when I said part about going to Vegas. But anyway, so she goes to Vegas, and the money's gone, and then she stops communicating with Crestview. So Crestview sues. Now, of course, what are the chances that Armstrong is good for a judgment for $500,000? Right, pretty low. So what?
Depends on how the Vegas trip went.
Depends on how the Vegas trip. Yeah, maybe. So now, what do you, if you're the investment company, you lost that money, and you got a defendant who's probably judgment proof? What are you going to do? What are you looking for? Any ideas? Deeper pocket, right? Aiding and abetting. Well, remember Dr. Smith, the plastic surgeon, who was on board with this? Guess what? He got sued for aiding and abetting the securities fraud. And, all right, so now the case against Armstrong sounds like it's probably pretty strong. The case against Dr. Smith sounds a little iffy to me. I mean, I don't know what his level of involvement was. Did he really know that she was making any misrepresentations or stealing the money? I don't know. But so what do you think Dr. Armstrong's lawyers did? Any ideas?
TCPA motion.
There you go. They filed a TCPA motion to dismiss. And the argument was this is based on communication between Armstrong and Smith, Dr. Smith, right? I mean, they had to communicate about this. So it's a matter of public concern. So TCPA motion. To cut to the end, the Fort Worth Court of Appeals said no, it wasn't a communication. the allegation was based on conduct, not communication. They focused on what the pleading said. All right, so it kind of raises the issue, to what extent can you sort of plead around the TCPA? And on the one hand, the court said, you can't avoid the TCPA just with artful pleading. All right, so you're not going to, if the claim is really based on a communication, you can't get around it just by not mentioning the communication in the pleading. On the other hand, they said, we are going to look at the pleading to determine what is this claim based on. And they said, no, this was based on his conduct, not on a communication. So, but that's just one case. I can see this coming up in other securities cases, and I don't think that's the end of the story. So that's Smith versus Crestview. Now, I've talked a long time.
And I
so
think that, learning from Elite Auto Body, one of the takeaways in that case is, even if you don't think it applies, even if you are the plaintiff and you get hit with one of these, you still need to take the steps to present your case. You want to make sure that you have clear and convincing evidence of all of your elements of your case, because even if you think it doesn't apply, if it goes to the appellate court and they think you're wrong and you haven't presented that evidence, that's it, that's the end of it. And now you're paying attorney's fees and you're hit with sanctions. So it's just, even if you don't think it applies based on this case, you're still gonna wanna go ahead and make your case if you're on the claims.
Yeah, I totally agree, and you'll see, and that's in our practice tips at the end of the outline. From what I've seen, usually where the plaintiff goes wrong is in not taking it seriously enough. The plaintiff will often kind of have an attitude of, wait, TCPA, no, that can't apply in this case. And so they kind of get caught flat-footed. So if you're the plaintiff, probably the safest thing is assume that it applies and file your evidence just in case. Yeah, Matt.
Exactly, a case like that where you're dealing with a securities fraud issue, a 10D issue or otherwise, does that argue for really bringing that case under federal law and federal court wherever you can to try to avoid the procedural elements?
Great question. If you've got a federal claim, that would also apply to trade secrets, right? Pretty much any trade secrets claim can be brought in federal court now. Can you avoid the TCPA by going to federal court? You want to take that one?
Well, the answer is maybe. Don't we love that as attorneys? Because there's been some mixed opinions on this, on whether moving to federal court. Courts have split on this issue. I was just talking to Scott Smith about one yesterday. Actually, the Stormy Daniels case was a federal, it was brought in New York, I think it was the district court in New York, and then it was transferred to a California district court, but it was decided on the TCPA. So, I mean, that would suggest just bringing your claims in federal court under federal statute doesn't necessarily help you, but there have been some other courts in Texas that have said, we don't think it applies.
Right, and there's at least one case in the Fifth Circuit pending right now that is probably going to resolve this and tell us if the TCPA applies in federal court or not. When I first thought about that issue, I kind of assumed it would not. The TCPA just kind of, it feels pretty procedural to me. But on the other hand, I went and looked at the briefs in that case, and there's pretty reasonable arguments on both sides. So I could see it coming out either way. My guess would be the Fifth Circuit's going to say no, it does not apply in federal court, but we'll see. So, but yeah, great question. Now, there's another way to sort of, or to get around or avoid a TCPA motion. You want to talk about the commercial speech?
Yeah, I would love to, since we have a case on appeal right now that's been there for a year. So the commercial speech exemption is the one area that the legislature carved out and said this isn't, TCPA isn't going to apply to these. And so we filed our briefing, I think 3 days after this Castleman opinion came out. We weren't aware that Castleman had been published yet. And so we spent a good deal of time in our briefing arguing why this placement of this one stupid comma, or lack thereof, should say that the communications have to be targeted towards the customers, why that would only apply to the last little phrase. And the Texas Supreme Court said, nope, we're not gonna construe this very narrowly and say that it applies to all of these categories. So in your outline, I'm not gonna read this, but essentially, if you wanna fit into the commercial speech exemption, you have to meet all of these categories, and that darn intended audience clause, applies to all of them.
Yeah, and let's take that, and this is a little speculative, but let's apply it to a securities fraud case. Okay, so a securities fraud claim is clearly a claim based on a communication, right? I mean, there's a representation made to typically an investor or a buyer of securities. And so if the buyer is sued, could the buyer say, well, that's based on my right of communication, and could maybe invoke the TCPA? I think you probably have a decent argument that the commercial speech exception applies to that. I haven't tested this, so I haven't fully thought it through, but that's at least something you would want to look at. Any questions on so far on the definitions or the commercial speech exemption? Let me go to, we already touched on this issue of does it apply in federal court? An analogous kind of, I think, issue is does it apply in arbitration? Is it, if you're, and including a FINRA arbitration, is it substantive law that, depending on choice of law principles, would apply to claims in arbitration? Or is it something that's more really just procedural and would conflict with the procedural rules in arbitration? I tend to think that it would not apply in arbitration, but I know that the issue has been raised, and Matt shared some experiences with me about how the TCPA motion could be raised in arbitration. One way is that a defendant could say, well, I want attorney's fees under the TCPA, and even if I'm not encouraged to file a motion to dismiss, what if the arbitrator just carries that issue to the final hearing? Okay, and so that's a way that you could argue that the TCPA motion is consistent with, for example, the FINRA rule, which generally discourages motions to dismiss. I mean, if you think about it, part of the point of arbitration is we want this to be streamlined. We don't want to have a bunch of motion practice and steps, and we just want to get to a final hearing and have it done. But it's an issue that people have raised. Yeah, Matt, you want to share?
Yeah, so Zach, one of the issues with TCPA, the way it's written, is that the definition is legal action, right? It doesn't talk about a case, it doesn't talk about bringing a case in court, and it certainly is expansive enough to include something else, some other form of dealing with the case, whether it be arbitration or something else. And we've seen cases where they brought a motion to dismiss. For instance, a lot of our FINRA arbitrations that involve employee defections, you have initially a case brought in court, right? So you have a TRO brought in court first, and then it moves to arbitration afterwards. And if you raise the TCPA claim in response to, say, a TRO filing, you can then arguably get a court to rule that the entire case should be dismissed on that basis, and that legal action is broad enough to dismiss all those matters, not only the lawsuit, but the underlying arbitration as well. We haven't seen that decided yet because most of the cases have gotten resolved quickly, as those cases often do, or they move to arbitration and lawyers say, wait, we don't want to have a decision on that because that could impact our clients' long-term interests. But it's certainly out there, and I think at some point someone's going to have a decision on that issue. And the other thing you've raised, which I think is also important, is FINRA's rule says you can't really have a motion to dismiss or discourage motions to dismiss before the hearing on the merits, but it doesn't prevent you, and we often see cases where all the motions that are out there are carried with the case until the final hearing, and then a court essentially uses those as a directed verdict motion and can rule based on any of the procedural or other mechanisms you have under Texas law. They just don't do it at the early stage of the case. Instead of a 30-day or 90-day ruling you have in the TCPA case typically, you might get it a year later, but it's still, you still get a decision by the court or by the arbitration panel. And it certainly is an issue that subjects, one, a normally decent case to a potential dismissal, and also to the recovery of attorney's fees for defendants in the case in Texas. So it's certainly an issue we're gonna have to deal with at some point.
Yeah, so Haley, let me ask you this. If you represent the defendant in a case that's subject to arbitration, I'm thinking you ought to at least consider this.
Oh, yeah, we had a case that we had handled it at the TRO stage and were pretty successful, but it was going to arbitration. Had it not settled, we were already talking about, and that would be one of the first things we did, would be to file the TCPA motion to dismiss. Because why not? I mean, it hasn't been tested yet, and that's been my approach, and what I'm telling people is, if it hasn't been tested, it's kind of hard to argue that it's frivolous, on that ground at least. Go ahead and try. If you don't think they have the evidence to back up their claims, go ahead and try to fit it in the TCPA and see, because until courts have ruled, it's just kind of hard to argue that it's a frivolous filing.
That's a great segue into the next point, which is attorney's fees.
Yeah.
And why does it matter whether the motion might be frivolous or not? You want to talk about that?
So, if the case is, if the legal action, is dismissed, then it's mandatory attorney's fees to the movement, so to the defendant. However, if the court finds that it's a frivolous filing, if the TCPA motion is a frivolous filing, then the court may, at their discretion, award attorney's fees to the plaintiff. And so that's why I am not aware of any cases as of yet that has actually awarded attorney's fees for a frivolous filing. I don't know, maybe last time we met, I think both of you and I said we didn't know of any. So that might have changed now, but I mean, right now I haven't seen any courts granting attorney's fees for frivolous filings, but I have seen a lot of courts that are ordering mandatory attorney's fees to the movements if they're successful on the motion.
Yeah, I think you make a good point that how could it be frivolous when everybody's still trying to figure out what this means, including the courts of appeals. And just to go back briefly to what we started with the definitions, let me just mention a couple opinions. There have been some interesting concurring opinions out there. The TCPA has been great for concurring opinions because I mean, that's basically what judges use when they want to sort of express their opinion about something, right? Without having to be binding or something. So, for example, there's a case called Gascamp versus WSP. That's First Court of Appeals here in Houston, and that generated two concurring opinions, one by Justice Jennings. And in his concurring opinion, Justice Jennings basically said this plain meaning of interpretation that the Texas Supreme Court follows, it just doesn't make sense. They've been too hyper literal, and they need to get back to what was the purpose of the statute, which is protecting constitutional rights. And he says they've kind of taken this sort of rigid, plain meaning approach, and I urge them to change that. He also, I think he urged the legislature to do something about it. Another concurring opinion, same Court of Appeals, this one by Justice Keyes in the Dresser-Rand case, which is also in the outline here. And her, kind of the same general idea, which is that we're applying this too broadly, except she took the view that she looked at the Texas Supreme Court cases and says, I think we're misreading those cases. I don't think they've told us to be so hyper literal. And she disagreed with the Austin Court of Appeals when it said in elite auto body that, okay, we have to apply this very literally. She thinks the Austin Court of Appeals was misreading the Texas Supreme Court precedent. And so kind of a different take on it, but coming back to the same theme, which is that there's a lot of judges out there saying that this has gone wrong and we need to rein this in.
I liked Justice Keyes' concurring opinion on that, and she basically just says, look, this was about First Amendment protection. That's actually the stated purpose. And so I hear you, Austin Court of Appeals, you're saying we need to look at the construction, how is this literally written, but she says you're ignoring the stated purpose, which is also found in the act itself. And so I thought hers was really well reasoned, and I think it lends itself to be used in other cases as new grounds are being tested. I think, citing to her, she has, I think, some good insight into what the stated purpose was and how we've kind of gone off the rails here.
Yeah, so I lied. That wasn't the end of the opinion part of the presentation. Because we're giving our opinions, but hey, we can't help it. Yeah, I mean, I think that the problem is you have, on the one hand, the statute tells us that its purpose is to protect constitutional rights, and on the other hand, it has these broad definitions. Now, Haley, do you think, would it make a difference? Let's say the statute specifically told courts not to apply the statute literally. Would that make a difference? What do y'all think? Would that? Well, guess what? In my view, it does say that, right? It said, what, do you recall what's the language?
I think also it's using construed liberally.
Exactly, yeah.
Yeah.
The statute itself says this statute should be construed liberally, not literally, right? To effectuate its purpose. And yet it seems like the courts are doing the opposite.
Yeah.
Anyway, questions, opinions, anything on that as far as how courts have applied the TCPA?
Anyone want to rail on the Texas Supreme Court?
One more question, Zach.
Yeah.
Do you think there's any room left for defamation claims under TCPA or defamation counterclaims?
You know,
Sorry, only if they
you go ahead.
fall within that commercial speech exemption, and I mean, it's gotta meet the definition exactly. That would be, I mean, and I think it's gonna be mostly like business defamation. As far as personal defamation, I mean, I think they're all gonna be subject to TCPA.
I think defamation is very interesting because it really exposes a problem with the TCPA. Defamation, by definition, is not constitutionally protected, right? Now, the U.S. Supreme Court has given First Amendment protection in this New York Times versus Sullivan case, and so there are constitutional limits on defamation law, but a defamatory statement is not constitutionally protected. So think that through. If it's defamation and the TCPA applies, then how does it make sense that the TCPA's purpose is to protect constitutional rights? It doesn't really make sense to me.
What if the substance of the communication that's alleged to be defamatory has something to do with, like, isn't there some public purpose or public interest thing to this statute? I'm not familiar with this at all, so I mean.
The interesting thing about that is the public purpose only goes to the right of free speech. They don't limit the freedom of assembly to public purpose. And so that's why, talking earlier about your collective goal can be something unlawful. And so the right of assembly, that one is not limited by public purpose. Now, the general freedom of speech is. But what has been defined as public purpose is really broad. I mean, goods, services in the marketplace, that's, in my opinion, that's really broad. There's also other things that it has to do with the health. And I also think the way the statute is written, it says it's basically including but not limited to. So it kind of leaves it open-ended for other similar categories.
So one issue we've also seen in the securities realm is when you have a broker who's being sued on a securities fraud claim or other complaint case in FINRA for damages, in order to have that expunged, say it's a frivolous claim, but in order to have that expunged, you have to allege or prove that the claim is defamatory in nature. But when you file the counterclaim for defamation, we've seen anti-SLAPP responses. And Texas is not California, but in California we had a case not long ago where they took it out of arbitration because of that. We filed a counterclaim for the sole purpose of the expungement of the claim, seeking to have it declared a defamatory statement that was damaging to the advisor because it was not true. The plaintiff in the case filed an anti-SLAPP motion outside of the arbitration in California State Court. The State Court in California looked at that and said, essentially, this falls under our anti-SLAPP case in our statute, and we can now dismiss your arbitration because of that. So there's a lot of ways this gets applied, and there are a lot of peripheral issues that I'm sure were not part of anyone's thought process in the statute that happening down in the securities environment where you've got certain things you have to prove in order to say get your advisor out of a hole after he gets a frivolous customer complaint, get that off his record. That you cannot now allege without running into a potential for having to pay the other side's attorney's fees on an anti-SLAPP motion.
Yeah, and I'll just add, if you're looking at it in the context of defamation, the case you want to look at is ExxonMobil versus Coleman, which is out of the Texas Supreme Court. That is also the case that Elite Auto Body primarily relied on for its plain meaning approach. So let's go to our last key issue, which is the procedural issue of staying or suspending discovery, which in many cases is really the key thing.
Yeah.
You want to talk about that?
Yeah, so if you're the plaintiff, you filed your lawsuit, you get hit with one of these TCPA motions, it stays discovery. So if you don't have your ducks in a row, if you don't have your evidence lined up, you can ask the court for some limited discovery, but it's at the court's discretion on whether they want to allow you to do that and how much they'll let you do. My understanding from talking to other practitioners, people in Harris County, the Harris County courts thus far have been allowing very limited. They're not reading this to allow things like depositions. So your discovery that you're going to be taking is going to be limited to written discovery. That can be problematic if you don't know, if you're basing it upon information you believe. If you don't know ahead of time, don't expect to get a whole lot of discovery to build up your case once you've been hit with one of these. Because discovery is stayed and it's not going to be lifted until the motion is denied. Then once the motion is denied, this gets into the next part of this, you have the right to an automatic appeal. And this is what are making these TCPA cases so frustrating, is that they completely just put a halt to the litigation, because once it's been appealed, then it's an automatic stay of the entire case.
Right, and my practice tip for the plaintiff on this point would be if a TCPA motion to dismiss is filed and you represent the plaintiff, I would very quickly evaluate, do I have enough evidence to support every element of each one of my claims? And if I don't feel confident that I do, I would immediately ask for discovery. And I would be very specific about, Judge, I need evidence to prove this element, this element, this element, and I need to get it from this person, and I need their deposition. Now, so you're building your record of, hey, I tried to get this discovery. And keep in mind, as much as, some judges might not agree with this, but in Texas, we're not required to have evidence to prove every element of our claim when we file a lawsuit. Now, there are people who probably want it to be like that, right? But that's not the way traditionally in Texas it works. So I think you should be very clear and aggressive and specific about saying, I need discovery. And then if it's denied, you got an issue for appeal, or said, well, I wanted to offer evidence of these elements, and I wasn't allowed to get the discovery I needed to do it. One other thing on discovery is that, well, let's get into the appeal issue, because it's related, right? You want to talk about, what happens if the motion to dismiss is denied?
So if it's denied, the movement has the option of an automatic appeal. We'll talk about whether you should do it or not in a minute. I'll save that discussion. But it stays the case. So if you are in a trade secrets case, you can see where this is problematic. If you don't have an injunction in place while this case is on appeal, then those defendants can be using your trade secrets, and I'm sure your damages might be building, assuming that you're going to be successful on your appeal, but there's really nothing in place to stop that. So this can be really problematic. The case isn't going forward. Sure, you can engage in settlement discussions, and then this is a great way for the defendant to kind of force those settlement discussions, but it stops everything. I mean, it halts everything.
Yeah, and you touched on something about, are you sure that you want to appeal? Like, be careful what you ask for. Think about it, let's say you're the defendant and your TCPA TCPA motion is denied, okay, yes, you could appeal, but maybe you're better off just leaving that, just going to summary judgment or something. I mean, if you really think that your defense is strong, maybe don't launch that appeal that's could put off the resolution for a year or maybe more. So, well, we've got some time left for practice tips. We've already covered some of these, but you want to take plaintiffs or defendants?
I'll do
Or
plaintiff.
I'll do plaintiff. Okay. So the first practice tip for plaintiffs is consider federal court or arbitration as a possible means to avoid the TCPA. Again, possible. We don't know yet for sure to what extent it applies in federal court or arbitration. Second practice tip for plaintiffs is when you're drafting your pleadings, keep the TCPA in mind, and you may want to plead things a certain way to sort of plead around it. Specifically, if you can avoid specifically alleging communications, that may help you avoid it.
And avoid conspiracy altogether.
Yeah, that's a great point. Right. I mean, and typically you usually don't need conspiracy. I mean, unless you've got some secondary actor and that's the only thing they did.
Yeah.
But other than that, you don't usually need it. I said before already, quickly evaluate if you have evidence to support the elements of your claim, and if you don't, move for discovery for good cause. Okay, the fifth one, and we haven't mentioned this yet, this is a real trap for the unwary. Let's say that you're the plaintiff, you've done what lawyers love to do, which is you've thrown in like 9 causes of action, everything you could possibly think of. A motion to dismiss is filed, and you think, I don't really need that Texas theft liability claim or whatever you threw in there, and so you non-sued something that you don't really think you can prove. And so you say, okay, so that's moot, so I don't have to worry about that now. Incorrect. There are a couple of appellate court cases that say once the TCPA motion has been filed and that defendant has asked for attorney's fees, you can't moot that by unilaterally non-suiting your claim. Have you dealt with that issue?
And it also goes for non-suiting parties, because we had a case where we were only one of several defendants, and so we filed our TCPA, so they just tried to dismiss us out. That doesn't work. Once you file a TCPA motion to dismiss, now you have made a claim for the attorney's fees and sanctions, and so the courts are saying you can't just get rid of the one defendant if you didn't have evidence against that one defendant. You shouldn't have included them.
So in that case, you're dismissed, but then you can go forward and get your attorney's
You can go
fees.
forward and
Push
on
the
the
motion.
motion and push for your attorney's
Probably
fees, yeah.
pretty good
And it's
evidence.
probably pretty good evidence that they tried to dismiss you out.
Yeah, and that was the scenario, I think, in the gas camp case that we cite, Houston Court of Appeals, where I think there was one party that was removed, and then they assumed that party didn't have to address it, and
Yeah, I think that was a plaintiff. They actually non-suited one of the plaintiffs in that case.
that's right, yeah.
And so they didn't file a response to the motion at all. And so when it went on appeal, they said, we didn't file a response. So even though the other 2 plaintiffs were successfully on appeal, they said, sorry, you still have to pay their attorney's fees. And so if you're the defendant, that's a win. Just getting one of the parties to pay their attorney's fees is a win.
Sure. My last practice tip for the plaintiff side has to do with damages. I think a lot of times damages is the most difficult element to prove when you haven't had discovery. And also, in a lot of cases, your damages are going to involve expert testimony. So certainly like in a lost profits case, you're often going to have expert testimony. So be careful about damages. Fortunately for the plaintiff, the Texas courts have said you don't have to prove a specific amount of damages at the TCPA stage. So it's enough just to offer some evidence that there has been some damage. But be careful about that, because that's often the difficult thing to show right at the beginning. Okay, you take it away with
Okay,
defendants.
so from the defendant side, kind of the reverse of what we just talked about. Think twice before moving to federal court or arbitration, because right now, until that issue is settled, if you're wanting to file a TCPA motion because you think they have no evidence, you just consider that aspect, that if it goes to federal court and the Fifth Circuit rules on this and says, no, we're not gonna apply this in federal cases, well, that's a problem. Evaluate whether to file the TCPA motion before the deadline. If you're going to file it before the deadline. But think about whether this is something that you want to spend time and money on. I generally think it's a good idea. It's something that we're regularly doing in our practice. But if you feel pretty confident that the plaintiff has evidence in that case, if you're in a trade secret case and you know that your client took the information, they have evidence of the information, they have evidence of customers that have been contacted. If you know that's the case, then you may potentially end up costing your client a lot of time and money that's unnecessary. On the other hand, if you think that, you know, there are problems with their case, there's holes, even just one element, I genuinely think it's a good idea to at least give it a shot.
Can I jump in on that
Yeah.
one? So I had a recent experience on the defense side where we did not file a TCPA motion. And the reason was that we had already had a temporary injunction hearing, and it was very close. It was what the judge actually tentatively ruled in my client's favor, and then changed his mind and granted an injunction. So it shows you it was on the fence. And at that point, my thought process was, I mean, the plaintiff, I'd have to concede, they probably did put on a prima facie case if the judge granted a temporary injunction, right? It's gonna be pretty tough for me to argue to that same judge that they haven't put on at least a prima facie case. So in that case, you may not want to file it.
Also, I'm told that a lot of judges hate this statute, and so it maybe isn't your best first impression. That's just maybe something else to consider.
Well, just got a small point on that issue you just mentioned. About 4 years ago, I filed about 3 anti-SLAPP motions in 3 different cases. I had very negative reactions in 2 of those cases.
Yeah.
From the judge. They're like, what the hell are you doing here?
Yeah, some judges are very outspoken,
Yeah.
and even if they rule in your favor, they won't be happy about it. So
Right.
just consider your reputation. I don't know.
Along those lines, here's a dilemma I've kind of thought about is, you know, I've made these statements just like on my blog posts, you know, giving my personal opinions, and obviously I said right off the bat, I think I don't like the statute, but I'm going to use it for my clients if it helps them, right? And I don't see any inconsistency there. I mean, if it was up to me, we wouldn't have it, but if we're going to have it, I'm going to use it.
Truthfully, our firm has actually been talking to a lobbyist to maybe work on correcting some of the issues here. And so then it's kind of ironic that we've filed several of these within just the last month. And I'm like, are we the biggest hypocrites on earth? But I mean, it's just, you have to do what's best for your client.
Absolutely.
So consider preemption arguments, and that's for the non-compete trade secrets or maybe other contexts of preemption that you'll want to keep in mind. And this is, to my knowledge, completely untested. And consider whether filing the motion could cause more delay in resolving the case, because that's always a consideration. Sometimes your clients just want resolution. They don't want cases going on forever. I mean, our case in Beaumont, the Court of Appeals in Beaumont, has been on appeal for a full year with no movement. Just consider that.
Well, Haley, it's also kind of a case killer if you're in a trade secrets case,
Yeah.
right? If you're really looking at an injunction case, and if the injunction is not granted at the outset of the case, and one of these is filed, by the time it gets heard by a court of appeals, nobody
It's not
has any interest in
secret
the injunction.
anymore. Yeah,
Right?
no.
Someone's had a year and a half to solicit clients or use the information or whatever it may be. And now you're really talking about damages, and you've essentially skirted the entire injunction.
Yeah, exactly.
Well, I want to thank the section for inviting us, and I want to thank Haley very much for a pretty short notice. I needed somebody who had more practical experience. I've written about it a lot, I've read about it a lot. I filed a motion recently, but she's done it a lot, so thank you.
Thank you. Thanks for inviting me.
Yeah, any questions before we wrap up? Yeah, okay.
Quick question. Do you guys find is the TCPA an all or nothing thing, meaning that if the defendant files a TCPA, have you seen courts grant it, but in part to where they'll dismiss, if there's 3 causes of action, they might dismiss 1 or 2 of them, but then keep
Yes.
one in?
Yes.
Okay.
Yeah, and that's part of our concern in that case on appeal. We feel pretty confident about a couple of our causes of action. There was one that we feel like we maybe go either way, but if they get, if it gets granted even in part, they still get attorney's fees.
Yeah.
Yeah, I can't cite you which case. I know I've seen cases where on appeal, the Court of Appeals said it was correct as to this claim and not as to this claim, so it is on a claim by claim basis. Nelson, you had a question too?
Yeah, I was, so, about 4 years ago, when I was dealing with all these anti-SLAPP motions, I was looking at the California anti-SLAPP statute as guidance. I was reading that in California, they interpret the anti-SLAPP statute there, that if there's ever a counterclaim brought against your claim, it's eligible, you can assert an anti-SLAPP motion against it. Do you think the same applies here in Texas under the Texas anti-SLAPP statute?
I think the answer is yes, and I think there have been cases where it was applied to a counterclaim. And the
Yeah, it's
reason for that,
a right to petition issue. I mean, I had a case on that where they brought that up, where literally argued if every single counterclaim brought affects the right to petition.
Right.
And so there's cases at the Austin Court of Appeals on that as well, where the Austin Court does the same thing, where they say they hate the statutes, but this is the way it's written. So.
yeah, and I think what plays into that is that the phrase legal action, like Matt said earlier, is defined really broadly in the statute. So it's pretty easy to argue that a counterclaim